Welcome to the latest employment law update from the employment team at Moorcrofts. If you don't know Moorcrofts, we're a niche law firm based in the Thames Valley. We concentrate on corporate and transactional work, commercial and technology, commercial property, and employment law. For those who don't know me, my name's Matt Jenkin. I'm the employment partner and I head up the employment team at Moorcrofts. And I'm delighted today to be joined by Lindsay Abbott. Lindsay is an associate in the team. I'm sure some of you who have registered and are looking at the screens now will recognise Lindsay and will have spoken to her before. She's a really key part of the team. It's great to have her do some sessions on this employment law update as well. We have got a packed agenda. So what are we going to look at today? I'm going to start off and I'm going to take a look at the retained EU law bill and what could potentially be a bonfire of employment law and why I don't think that's actually exaggerating the current state of play. Lindsay's then going to take a look at belief discrimination. 2022 certainly seen our fair share of belief discrimination cases, both in terms of what is a belief and also what amounts to discrimination. Lindsay and I think it's potentially the new battleground for employers and employees. Then we're going to have a short break, probably 5-10 minutes, depending on the timings, just so you can recharge your caffeine levels and grab a coffee and a tea. Then I'm going to have a look at some other employment law changes that I think you should know about, and Lindsay's going to finish off with a case update. Before we start, though, just some housekeeping. We are recording the session, and we'll be sending a link to the recording and the slides out. So feel free not to have to write down everything that we say, because you'll be getting that to enjoy at your leisure. It also means, of course, if you're only able to join us for part of the session, you'll still get the opportunity to take a look at what we were talking about for those bits that you can't miss. I appreciate it's a big time commitment for people, and you know, not always everyone can stay till the end. In terms of questions and answers, we will try and deal with some questions and answers, but we'll deal with those, I think, at the end, because we've got a packed agenda, as I say, to get through. And please do use the Q&A function. If there's particular questions that we can't answer, what we'll have a look at doing is maybe doing a question and answer sheet that we can distribute as well in the coming days. So I think with that having gone through the housekeeping, let's turn to the first session and the retained EU law bill, what I classify as a bonfire of employment law. And of course, as employment lawyers, you've probably heard me talk before, particularly around the impact of Brexit and whether that would lead to a bonfire of red tape or a bonfire of employment law. And certainly to date, that hasn't been borne out. But what about the retained EU law bill? Is this just an employment lawyer talking up the potential to make a talk more interesting, or are we actually going to see some fairly fundamental changes to employment law? Well, the bill, to give it its full name, the Retained EU Law Revocation Reform Bill, sounds quite innocent, doesn't it? It sounds like it's probably to deal with some obscure legislation that's being cooked up by some technocrat in Brussels. Actually, I think you couldn't be further from the truth with that. What it does is a number of things. First, it sunsets retained EU law, which again kind of says almost like kind of a gentle process. What it means is, though, that all EU-derived law in the UK will be turned off with effect from the 31st of December 2023. It can be preserved, but the government can only do that until the 23rd of June 2026 and would need to bring in specific provisions to do that. They'd need to actually elect that certain regulations or legislation would continue. And the 23rd of June 2026, of course, is the 10-year anniversary, I think, of the Brexit vote. So some import there, I think, in terms of that date. So not only does the bill turn off all EU-derived law with effect from the 31st of December 2023, it also removes 3 key principles, and we'll look at this in a bit more detail when I give some examples of how I think this bill will impact on employment law. But it removes 3 principles that are used on a regular basis at the moment in terms of interpreting legislation, and that's the direct effect of EU law, the supremacy of EU law, and the general principles of EU law. Now, and this isn't a political point on Brexit at all, but I think most people would expect that the outcome of Brexit would have been, for example, that the supremacy of EU law would no longer apply. So again, perhaps when we look at it just in the abstract there, not a huge surprise that that's coming in. Also, what does it do? It gives the government what people call Henry VIII powers, and this is the government's power without necessarily huge scrutiny by Parliament to revoke, restate or wholly rewrite EU-derived legislation if they choose to implement it from the 1st of January 2024. If they do rewrite it, it must always reduce the burden rather than increase it. Now, this, I'm sure lots of you will be pleased to know, isn't a constitutional lecture. And I'll leave it to others to debate whether giving a government these Henry VIII powers is a good or a bad thing. It happens, but very rarely. I'd be interesting to see how the government uses that. So what? As I say, you could look at this and say, is this just one of those bits of kind of carryover from the Brexit debate that isn't going to have a major impact in the UK in terms of employment law? Well, I think exactly the opposite. This has the potential, I think, to be the biggest change in employment law in my practicing career as a solicitor, which goes, I'd say 25 years, if not approaching more like 30 years these days. And what happens is the bill turns off all employment law which comes from the EU. Now, the government can choose to save or amend the legislation, but what we're talking about here isn't, minor employment rights. These are lost potential of employment rights used on a daily basis. So I think there is the potential that workers' rights are diminished to a huge degree. And also it'll create uncertainty for employers as a result. And we'll see that as we go through. Now, to give a practical example, let's take the working time regulations. Now, the working time regulations implement the Working Time Directive. So the working time regulations are EU-derived employment law. And what would we see disappear potentially on the 1st of January 2024? What would we wake up to? Well, there wouldn't be a daily limit of 8 hours a day on work for children, because all the rights with regard to the hours of work for children are contained in the working time regulations, so would disappear. Also, rights to daily and weekly rest breaks. Those would disappear, again, contained in the working time regulations. Even the basic right to paid holiday, which was only introduced way back when the working time regulations were introduced, that it gave us the first statutory right to a minimum period of paid holiday, currently 5.6 weeks per annum. So that would go potentially. Would also see some more recent rights. You may recall that the regulations relating to holiday were amended in light of the pandemic to allow people who'd been unable to take their holidays as a result of the pandemic to carry over unused holiday into the next 2 holiday years. Again, that's EU-derived employment law, so would disappear. And it's not just working time regulations. Things like the obligations on the part of employers to carry out health and safety risk assessments. Now, I'm sure some employers would look at risk assessments and think, well, okay, sometimes maybe perhaps they're slightly over the top, but they're there for a reason, to protect health and safety. And I think to have those abolished without anything to replace them would be extremely concerning. We could also see all the protections that we have in place for fixed term and part-time workers, the right to be treated pro rata similarly to permanent employees unless you can justify the differential in the treatment. That would all disappear. And of course, given that particularly part-time work, and we'll see some changes with flexible working is being encouraged, then I think potentially that could have a huge impact. And latterly, as an example, and those of you who've heard me speak before, and I know probably there's some clients on this session as well, will know that I'm a 2P anorak. I enjoy looking at all those cases around what happens when businesses are bought and sold and how the transfer of undertaking regulations apply. And these are the regulations that say when a business is sold, the employees transfer automatically on the same terms and conditions of employment with continuity of employment preserved. Now, if we think back to what the position was before 2P was introduced, and I think the first iteration of the transfer regulations was 1981, well, there was the argument that the employees on the sale of a business, their employment would actually terminate. That would create, I think, a huge degree of uncertainty. So I think from that, we can hopefully see that we're not talking about obscure pieces of employment legislation here. We're talking about employment rights that are used on a daily basis. But I'm sure as I can hear people talking to their screens as I'm going through this, because as I said, can the government just restate all of those regulations and get around these issues that way? The answer is yes, of course they can, but it's not as simple as that. Reason why it's not as simple as that is there's a problem with just restating the legislation. So if the government just said, well, look, we're not going to get rid of the working time regulations, we're going to introduce legislation that says the working time regulations will continue from the 1st of January 2024. The problem with that is we've seen all those interpretive principles are wiped clean from the slate. There's no phasing out, there's no transition period. And so we don't know how that working time regulations will then be interpreted until new decisions emerge. And that'll create a vacuum and that'll create uncertainty. Because clients will ring me up on the 1st, well, hopefully not on the 1st of January 2024, maybe to give me until the 2nd. But when they start asking questions around the interpretation of the working time regulations, I won't then be able to call on that huge body of case law to actually answer that. And I'll demonstrate that by taking a look at holiday pay and holidays. Now, as I'm sure some of you will have heard me talk about and Lindsay talk about on previous webinars, there's been a whole history, hasn't there, of case law around working time and holiday entitlements. And all that case law calls on EU principles. So the right to be paid normal remuneration during holiday. We've all, I would say, enjoyed the cases. We've all got to grips with the cases. Bear Scotland, for example, which says when people are on holiday, they're entitled to be paid normal remuneration. And we now know normal remuneration includes things like overtime and commission and certain bonus payments. The reason why it includes those additional payments is because the working time regulations have been interpreted using EU principles. Similarly, the right to carry over holiday not taken due to sickness absence, again, involves the interpretation of EU principles, use of EU principles. And again, more recently, the case law that says workers have been misled over status, so misclassified as self-employed when in fact they should have had a worker tag and been entitled to rights that workers have, such as paid holiday. They don't lose their entitlement and can potentially claim that back for the entire duration of the engagement. That's all derived EU employment law. So on the 1st of January, 2nd of January 2024, when a client rings me up and says, Matt, I can see that the working time regulations still apply because the government's chosen to apply them. But what should I pay my staff now they're on holiday? I won't know the answer to that because those legislative and interpretive principles will have disappeared. And so there will be some uncertainty, for example, as to what pay they should receive. There'll have to be a series of case law to go through to establish that potentially. As I say, huge uncertainty for employers. So what will happen? Do I think it's the government's intention to set fire to this amount of employment law legislation? No, but I think that could be the consequence of this. And we're waiting for the government to confirm its intentions. They seem to be under pressure almost weekly to give some guidance on what they're going to do in terms of employment law particularly. I know kind of my own trade union, my own kind of representative body, the Employment Lawyers Association, has put together a really good paper which they provide to the government saying, look, okay, if this bill is what you want to introduce, that's fine, but you need to be aware of the consequences of that and you need to manage those consequences. And of course, as I say, the government can choose to preserve EU-derived employment law. But there's a lot of legislation and case law to review. And the clock is ticking. In real terms, turning off the tap with effect from the 31st of January 2023 doesn't give us a lot of time to prepare if we're going to lose a lot of this employment legislation. And there's certainly bandwidth issues, not just bandwidth in terms of what the government needs to do, but also bandwidth in terms of the other challenges that the government's facing and the parliamentary time that will take up. And of course, it's not just employment law to deal with. I think I saw an estimated 3,400 or 3,800 pieces of legislation or statute to review. Each one of those would need to be reviewed, a decision taken on whether or not they are going to apply from the 1st of January 2024, and what interpretive principles are going to apply when they do carry that legislation forward. That is, I think, a huge amount of work to be done. We are still in a period of uncertainty, and we're still waiting for the government to confirm the position. I think what we might see is the government recognising that actually they're not going to be able to do this by the end of 2023 and introducing legislation which pushes some of the legislation back, perhaps to change in June 2026, just to give them that extra period of time. But certainly I do think it's going to create a period of uncertainty, and I think the next few months it's definitely one to keep an eye on, and we'll certainly be including this in our further webinars just to give you an idea on where we are. But as I say, from an employment law perspective, I think this could potentially, if nothing changes, see the biggest change in employment law, certainly in my practicing career as a solicitor. I hope you found that useful, if not a little bit scary, because I always get scared when I think about the implications of it. And I just think it's something that we need to give some thought to, and we'll keep you updated on that. I'm going to hand over now to Lindsay, who's going to take us through her session, which is looking at gender belief discrimination and what is in effect we think the new battleground for employers. So Lindsay, over to you.
Thanks, Matt. Good morning, everybody. So we're talking about belief discrimination. The reason that we're calling this the new battleground is because we've seen a lot of cases come through this year which concern this belief and how you manifest that belief. So we're going to be kicking off with the case of Forstater and CGD Europe. So I'm sure you've all heard of her. And then we're looking at the case of Makareth and the Department of Work and Pensions and Advanced Personnel Management. Moving on to a case of Miss Bailey, who was a barrister who worked for Garden Court Chambers. And then Freemars and the Royal Veterinary College, which deals with ethical veganism. Then McClungan, Deuce and Babcock, which is a case about football supporters. And then Waters and Active Learning Trust. So let's look at Forstater. We talked about this before in previous webinars, some of you may remember. She was a visiting fellow at CGD Europe, and she did not have her contract renewed after she'd published a series of social media messages describing transgender women as men during some online discourse, and concerns were raised by staff at CGD and complaints were made about her behaviour. So they didn't renew her contract, and she took them to an employment tribunal who had to decide, did her gender critical beliefs qualify as a protected belief under the Equality Act? So essentially she believed that a woman is defined by her sex, and you can't change sex no matter how you dress or what procedures you undergo or how you live your life. You are born with your sex, and that was her gender critical belief. So the judge in the employment tribunal ruled that her beliefs did not qualify as protected under the Equality Act because they were incompatible with human dignity and the fundamental rights of others. She then appealed against this judgment, and the judgment was in her favour. As with the original hearing, the appeal was on the narrow issue of whether her beliefs were protected. So the judgment found that they were, and that they did meet this requirement, that they were not incompatible with human dignity and the fundamental rights of others, and that they were worthy of respect in a democratic society. A full merits hearing then concluded that she had suffered discrimination by CGD, so she won her claim. Now, what the tribunal said in this is that there is a difference between holding those beliefs and then discriminating or harassing others because you hold those beliefs. So what this case doesn't mean is that you can then misgender trans people or harass trans women or discriminate against anyone on a protected ground because of your beliefs. So there's a real emphasis here on tolerance as well in terms of the employer. You have to be tolerant. You can't just dismiss someone because they have a different opinion. It is okay to think differently, but it's not okay for those people that think differently to discriminate against others because of their beliefs. And what the tribunal had said in this case was that her contract wasn't renewed because of her beliefs, and that's why it was discrimination, not because of how she treated people. Now, I'm just going to run through the 5 criteria that employment tribunals look at when they're deciding whether or not a belief is protected under the Equality Act. And this was the case of Granger and Nicholson. These 5 criteria run through all of the tribunal's decisions in the cases that I'm going to talk about this morning. And I'm just going to read them out. So the belief must be genuinely held. It must be a belief and not an opinion or viewpoint based on the present state of information available. And it must be a belief as to a weighty and substantial aspect of human life and behaviour. It must attain a certain level of cogency, seriousness, cohesion and importance. And finally, and this was the key in the Forstater case, and this was the difference between the Employment Tribunal and the Appeal Tribunal, must be worthy of respect in a democratic society and not incompatible with human dignity or conflict with the fundamental rights of others. So that's what the tribunal look at. Now we're going to look at the case of Moorcrofts, which is a contrasting case here to that of Forstater. And this was against the Department of Work and Pensions and Advanced Personnel Management. So this gentleman worked for the agency Advanced Personnel Management, who put him into work for the Department of Work and Pensions. He was a Christian, he was a doctor, and he was engaged to perform health assessments on claimants for disability-related benefits. Now, during the induction process, he stated that his beliefs meant that he would not use preferred pronouns when dealing with transgender service users. Now, this was at odds with the DWP's policy on this, that provided, amongst other things, that a transgender service user could present to any stage of their transitioning when they were going for these health and disability assessments. So the doctors should always treat them with respect and refer to them in their presented sex, gender at all times. You should address them in their presented sex. That's what the DWP's policy said. And he said he didn't think he'd be able to do that. So the DWP performed an assessment. Could they accommodate these beliefs? Could they perhaps have him only working with non-transgender clients or in a non-client facing role? So as they were going through this assessment, they parted ways. He left for work one day saying he couldn't carry on. There were some emails that went backwards and forwards. Ultimately, Mr. Moorcrofts brought claims of direct discrimination, harassment, and indirect discrimination on the grounds of religion or belief. Now, it wasn't in dispute that his Christianity was a belief. It's a protected belief. It's a religion. What he put forward when he was making his claim was that and what his case depended on was him demonstrated that his beliefs and his lack of beliefs in transgenderism could be protected by the Equality Act. Now, what he said was that the Bible says a person cannot change their sex or gender at will, and attempting to do so is pointless, self-destructive, and sinful. And he had a lack of belief in transgenderism and gender fluidity. He did not believe that a person can change their sex and impersonating the opposite sex is beneficial. He didn't believe that. He didn't believe that society should accommodate transgenderism and impersonation of another sex. And it would be irresponsible and dishonest for a health professional to accommodate or encourage somebody to do that. Now, what did the Employment Tribunal decide? So they decided Christianity was a protected characteristic, but he didn't meet all the criteria in Granger and Nicholson, specifically the last 4 criteria. He didn't meet those. And that the provision, criteria and practice that the DWP was using, which is basically use the service users preferred pronouns and that the doctors had to conform to the policy, could be objectively justified. And the objective justification there was protecting the rights of others, of the transgender service users. So he appealed to the EAT, and they confirmed that for a belief to qualify for protection, it's necessary to establish that it doesn't have the effect of destroying the rights of others, which is what it was found to be doing here, because he was misgendering those service users. And the Appeal Tribunal found that the DWP's conduct was not because of his belief, not because he was a Christian, but the way that he was treating others, so the way that he was treating those service users. So the big issue here is really that there is a distinction between belief and what your belief is and how you manifest those beliefs. So that's what you would be looking at as an employer if you feel, as in this case with Mr. Macaret, that his belief is making him treat other people badly or discriminate against others. So now we're going to move on to the case of Miss Bailey. So she's a criminal defence barrister at Garden Court in London, and she has gender critical beliefs as well. A bit like Miss Forstater, she believes that a woman is defined by her sex and sex is immutable, and she disagrees with those who say that a woman is defined by gender, so that you can be gender fluid and you can change in that way. And she believes that sex is individual to identity as well. This lady, she's a lesbian, and she co-founded the LGB Alliance campaign group, and this campaign group also opposes Stonewall's view, who were also involved in this case, that transgender women are women in the eyes of the law. So there were complaints made about her. There was a Twitter storm. Everybody got very embroiled in this, and Garden Court said that they were investigating concerns about her in line with their complaints policy, and that they were taking it very seriously. So she went to an employment tribunal, and the tribunal was very clear about this, and there was part of her claim that she didn't win. But what they did decide was that she had been discriminated against when Garden Court had tweeted that her comments would be investigated. Now, this is an employment tribunal decision, so it's not binding, but it's sort of showing the direction of travel, and it's similar to the Forstater case and some of the other cases that we're looking at as well. The treatment complained of was about the way that she'd manifested her belief and the belief itself. The Equality Act protects both sides of opinion, but really it's about how you hold and express your beliefs, and that is in a way that shouldn't discriminate or harass others. And she was awarded £22,000 in damages, in compensation for injury to feelings when she won her case. But again, this adverse treatment was because she'd expressed a view and she held those beliefs. She hadn't discriminated and harassed others. So now we're going to move on to the case of Ms. Free Miles, who was an ethical vegan. She was a veterinary nurse who worked for the Royal Veterinary College, and she believed that animals held innate value. Now, she was arrested in 2019 in connection with alleged burglaries by the Animal Liberation Front, which is an animal rights group which endorses breaking the law for their cause. Following her arrest, the college found that she was keeping a turkey in her flat that she'd liberated, and this breached a no pets policy, an accommodation agreement, and she posted some pictures on social media as well. She was dismissed, and she brought discrimination claims and unfair dismissal claims against the Royal Veterinary College on the grounds of her belief in her ethical veganism. So the tribunal found that her belief in ethical veganism didn't satisfy the fifth criteria of Granger, if you remember, that it's worthy of respect in a democratic society. And they took a very strong stance in their government, in their decision, saying that the laws of this country are made by the democratically elected representatives, and it's not up to individuals to decide which laws they will and they will not follow. And she had been unlawful in her actions, essentially. And any belief that advocates or makes criminal activity obligatory is not worthy of respect in a democratic society. But they did make it clear that if her ethical veganism had encompassed some positive action and lawful action, such as protests, then their decision might have been different. And there was a case a couple of years ago, which we blogged about, it might have been in another webinar as well, about ethical veganism. And it was a groundbreaking case, and that's the case of Kasip Mitjana and the League of Paul Sports, which said that ethical veganism can be a protected philosophical belief. In this case, this gentleman lived his life through veganism. Really, it went through every part of the way that he lived his life, including to do with climate change and the clothes that he wore and everything, the way that he lived his life. So that was protected. And what the tribunal said in this case was, if a belief manifests itself in illegal action, that's going to be highly relevant in the decision. So any philosophical belief which endorses criminal action and civil disobedience is not going to be worthy of protection. Okay, so now we're going to be moving on to the case of McClung and Deuce and Babcock. Now this is about football supporters. I'm not going to pretend I know very much about football. I don't, but I know that it is very, very important to some people, including Matt, as some of you will probably know. So this gentleman here, he worked as a contractor for Deuce and Babcock, and he alleged that he was denied work because of his support for Glasgow Rangers. He was a lifelong fan. He'd been a fan for all his life, and he lived his life to support this football club. When he was denied work, he alleged in his case to the Employment Tribunal that he'd been told by a colleague that you're unusually okay for a Rangers fan. And the manager who denied him work was a fan of the rival team, Celtic. I think it's Celtic and not Celtic. Again, forgive me, I don't know anything about football. But during the claim to the Employment Tribunal, he put across that being a supporter of Rangers was as important to him as going to church. He didn't go to church, he went to the football. He went to all of their games. He was a very committed fan, and everything, it was a belief to him. He had a Sky Sports subscription, etc. So what did the tribunal decide? They decided that it was a belief that was genuinely held, which is the first criteria of Granger, but it did not satisfy the last four Granger criteria. And what the judge said in this case was that she totally accepted that he woke up on match days buzzing and he was very excited and it meant a lot to him. But she said that that was very personal to him and it was subjectively important to him. And also she accepted, no doubt, to millions of other sports fans as well. But she said it didn't represent a belief as to a weighty or substantial aspect of human life and didn't have any larger consequences for humanity as a whole. So she decided that a belief in Glasgow Rangers Football Club would not qualify as a philosophical belief. I know that there might be a lot of football fans out there who probably wouldn't agree with the judge in this case. And I think probably one of the takeaways of this case is that perhaps just to be careful of workplace banter, because obviously in football terms, people do have very strong beliefs and it can lead to heated discussions at work. And I think in this case, clearly this is about local football teams, but at the moment, if you've got people in the office of different nationalities and they are arguing about the football, then you might have to be careful as an employer how you control that that passion and that potential banter as well, because it could potentially lead to claims of discrimination on other grounds. Right, so we're going to look at Waters and Active Learning Trust here. So this is a case about a Christian gentleman again. So he was a caretaker. He worked for the Isle of Ely Primary School. He also worked outside of that role as a Christian minister in his own time. Now, he'd made some tweets about gay pride, and he'd said, this is a reminder that Christians should not support or attend LGBTQ pride events held in June. They promote a culture and encourage activities that are contrary to Christian faith and morals, and they are particularly harmful to children. So again, there was a backlash on social media. There were complaints to the school about what he put. And the school said that they were going to investigate those. And they sent him a letter telling him that they were going to look into misconduct or gross misconduct because what he'd done was harmful to the reputation of the school. Now, they decided they were talking about whether or not they should suspend him. So that was the head teacher and the HR director. Should they suspend Mr. Waters? But instead, they decided to remove him from some parent-facing duties at the school gates, for example. They then conducted an investigation, but he resigned the day before. He was invited to a disciplinary hearing, But he resigned and gave 1 month's notice, saying that it had become clear to him that there was no freedom of speech at the school, and he couldn't believe in what he believed in, which was Christianity. The disciplinary hearing was postponed. It was eventually held, and he was given a final written warning. He took his claims to tribunal. He also appealed the decision to dismiss him, but that was not upheld. He appealed the decision for the final written warning, and he appealed, but that was not upheld. Now, what the tribunal said when he took those claims to court was that he'd basically jumped too soon. Had he waited for the final written warning and then resigned, he may have had a successful, unfair, constructive dismissal claim. And the judge said that if a comparator had held similar beliefs to him for non-religious reasons, for example, they weren't religious, but they didn't believe in gay pride, and they had made that tweet, they would also have been at risk of complaints and discipline and a disciplinary. But his claims were dismissed for unfair dismissal. But they did find that he had been discriminated against indirectly. And this is because he'd made the tweet outside of work on his personal account as part of his role as a Christian minister. And the judge said to curtail his freedom of speech outside of work, which is an important role, part of his role as a Christian minister, and thus part of freedom to practice his religion, must be done with some exercise of caution, and only in the clearest cases, whether the rights of others are being damaged, should the school intervene to prevent the claimant from preaching. So again, this was a bit of a Twitter storm, just like in Bailey and in Forstater, and everybody was getting involved and embroiled in it. And I recently heard another barrister comment on this to say that employers mustn't make the mistake of thinking that Twitter is real life. We all know, don't we, that on social media, people will do and say things that they would never do or say in real life because they feel anonymous or protected. So it is easy for people to voice their opinions in that way. Overall, for an employer, there is a big difference between treating somebody in a way because of the fact of the belief they hold and treating them in that way because of the way that they're manifesting that belief. And that's what's really key, I think, throughout all of these cases. Respectful discussion is okay, but as an employer, don't respond in a knee-jerk way unless somebody's actions really go beyond what is acceptable in a respectful and healthy debate. So that concludes my session. So I think we're going to have a break now, but I think I'm handing back to Matt.
Hey, Lindsay. Yeah, thank you for that. Yeah, really fascinating look at some of the recent developments in belief discrimination cases. You're right. I was particularly interested in the McClung case, all about whether being a football fan was capable of protection on the grounds of belief. I must remind myself next time I find myself stuck on the M6 at 1 o'clock in the morning because they put it down to one lane on my way back from a certain team at Anfield, that it's a lifestyle choice and not a belief, and therefore one that I can change at any stage. But I think what also I think it does demonstrate as well is something that Lindsay and I see an awful lot these days, is that in the McClung case, he didn't have 2 years service, so couldn't bring an unfair dismissal claim. And so he was casting his net very widely to try and find a claim that he could bring. And that claim was a discrimination claim because it doesn't require 2 years service. And so I do think there's elements of caution out there for employers as well, is that even if you've got employees who've got less than 2 years service, they are becoming quite inventive now around some of the claims that they can bring. So it's certainly a word of caution that even on some of these belief cases that you think there's no way that could be a protected belief, we are going to start seeing challenges to that at the employment tribunal. So thank you, Lindsay, for that. And there are some ongoing changes that we need to be aware of. So let's have a look at first things, a couple of things that we know are going to happen. First of all, an increase in the national minimum wage. This was announced in the recent budget update by the new Chancellor, Jeremy Hunt, and that will apply from the 1st of April 2023. I put those new rates up on the slide. I'm not going to read every one of them out, but I would, of course, just highlight the national living wage rate for those aged 23 and above. That's kind of the headline rate for national minimum wage. That's going to increase to £10.42 an hour from the 1st of April 23. That's an increase of 9.7% from the current rate. Now, that increase in the national minimum wage, of course, does have an increase in staffing costs from April, and employers are going to have to start costing those increases into their staffing budgets. And also, I think as well, you start to see more and more employees falling within that national minimum wage provision. I know when I first started talking to clients about the national minimum wage, for a lot of them, even their salaried paid staff would be way above the rates, and therefore the intricacies of the regulations never really applied. Whereas actually now, with those rates increasing, more and more employees perhaps will find themselves within the national living wage bands, and therefore it's just worth, I think, just doing some checks, perhaps for your lower paid salaried staff, that you're not falling foul of the minimum wage regulations for them as well. Also, I think just something I saw yesterday, not on the slide, but just a quick update. The government has also announced the increase in rates from the 1st of April 2023 to statutory maternity pay. So that's going to go up to £172.48 per week. Statutory sick pay is also going to increase from April, and that's going to go up to £109.40 per week. So an increase on the current £99.35 a week. So just some increases in those rates that, again, to be aware of. Also, we saw on Monday, just to make sure to keep me on my toes when I'm preparing for these webinars, the government announced its response to making flexible working the default consultation, and they've announced what changes they're going to make to flexible working. The big change, the one that's probably caught the most attention, is making the right to request flexible working a day one right. So removing that service qualification, which I think currently stands at 26 weeks. The important thing to note in that, though, is it's still a right to request flexible working. So when I think they call this making flexible working the default, that's not the case. It's not a right to work flexibly. It's still a right to request to work flexibly. An employer can consider the request and turn it down. And the 8 business reasons that are currently in the regulations for turning down a request are going to stay. The government's not going to change those. What they are doing on top of this, though, is introducing a new requirement for employees to consult with employers to consult with their employees when they intend to reject their flexible working request. So my experience is most employers do discuss flexible working requests with their employees, but it's hoped by ensuring that this dialogue takes place that there'll actually be more, I think, consideration of requests. They're also changing some of the processes. They're going to allow 2 statutory requests in a 12-month period rather than the current one. And they're going to cut the period of time by which an employer has to respond to a request from 3 months to 2 months. And they're also going to remove the existing requirement, which I always felt was a bit odd, that employees have to explain to their employer what effect, if any, the change would have and how that effect could be dealt with or mitigated. That can be quite difficult for employees to do, and I think probably put some employees off making formal flexible working requests. But we're certainly going to see some changes to this. But as I say, it's not making flexible working the default. It's just changing the process by which employees can make that request for flexible working. No timescales on when this change is going to be introduced. There's an employment bill, a little bit of what I'll talk about at the moment, or a private members bill, which will have some impact on this. But there's no date yet, but we are going to see some changes to flexible working as a result. One thing that won't be happening anymore is reform of IR35. On the 23rd of September 2022, as part of their, well, not mini budget financial statement, whatever it was, Kwasi Kwarteng, the then Chancellor, announced that the off-payroll working rules were to be repealed from April 2023. The off-payroll working rules are an offshoot, really, of IR35. IR35, of course, is the legislation, the tax legislation that applies when an end user client is engaging typically a consultant to provide services to it, but they're engaging them via the consultant's personal service company. And that is quite controversial, particularly because of the tax treatment and perhaps what's not being paid in terms of tax. Off-payroll working was the change to IR35, which applies to medium and large organisations who are end user clients and engaging consultants in this way. For those organisations, they were required to carry out a status determination. And if that status determination found that if the relationship between the individual and the end user client would have been a deemed employment relationship, then the end user client, if they were the payer of the fees to the consultant's personal service company, would need to deduct tax and national insurance in the same way as they would have had to deduct that for paying their own employees. That caused a huge amount of work for organisations. I know I spent a lot of time working with clients talking about off-payroll working and the reform of IR35. It was always in Liz Truss's sights. I was on a webinar at the beginning of September when I predicted that one of the things that Liz Truss would look at, given some of the speeches she was making, was reform of off-payroll working, and therefore had a smile when I saw that that was actually going to come true. I was less cocky when on the 17th of October it was announced that that proposed change was not going to apply. So IR35 off-payroll working rules will continue to apply, and you'll have that continued approach, different approach between medium and large end users compared with small end users of services in this way via consultants. So definitely one to keep an eye on, but not the kind of the repeal that I think a lot of organisations were looking for. We've also seen an extension on the ban of exclusivity clauses. I couldn't quite believe it's been in place since May 2015, making exclusivity clauses unenforceable in 0 hours contracts. Now, exclusivity clauses are those clauses in contracts of employment, which typically prevent an employee from working for another party whilst they're employed by their employer. Now, in 0 hours contracts, that's of course hugely controversial, because a 0 hours contract doesn't give that worker any guarantee of rights. So on the one hand, an employer is saying, we don't have to give you any work, but you can't take up employment with anyone else in the meantime. 0 hours contracts, my experience is lots of those employees are on low pay and will need to find alternative employment if that employer isn't going to give them any work for that period. And so, not surprisingly, those exclusivity clauses were banned. That ban has now been extended, was enforced from the 5th of December 2022 to low paid workers. Those are people who earn whose earnings don't exceed the national the lower earnings limit, which is currently £123 a week. So right at the margins really of paid employment, in my view. Interestingly, it does provide automatic unfair dismissal protection to employees in these circumstances, no qualifying period for protection. What you do need to do is, if you've got low paid workers, certainly anyone you think might be around the lower earnings limit, that you audit and amend contracts to remove those exclusivity clauses, because they are now banned in those contracts. For contracts that don't fall within that, where employees aren't low paid or 0 hours, of course they can still be included, but some thought still needs to go into the drafting. Are you going to ban an employee from working for any employer, or is it just competitors? Those are things which I think need to be looked at, even if you're going to have those exclusivity clauses in contracts for other employees. We've also got the Transport Services Minimum Service Levels Bill in the news today, Financial Times talking about it. This is the legislation the government wants to introduce, really to try and reduce the impact of strike action in the transport sector, and probably more specifically within the rail sector. I'm sure there's many of us out there have been affected by strike action. One of the things that strike action is always going to be is inconvenient. There's no point taking strike action if it isn't inconvenient, in my view. That's what's going to force the employer to the negotiating table. But of course, it's been hugely disruptive for individuals as well. And so it's not surprising that the government's trying to look at how it can reduce the impact of strikes, particularly in the rail sector. And what this legislation would do, it would set service levels. So perhaps in the rail sector, it would say, if there's strike action on a particular network, there has to be 20% of the timetable kept in place, and the unions would be required to take reasonable steps to maintain employee numbers to ensure those minimum service levels are maintained during strike action. Now, in terms of setting the service levels, initially that would be for the unions and the employer organisations to agree. If they can't agree that, it's then defaulted down to the Central Arbitration Committee, the CAC, who would set those levels. And even in some specific circumstances, the government could intervene and set them. Now, if the trade unions don't take those reasonable steps once this bill becomes law, they'll lose their immunity from industrial action claims. So things like inducing breaches of contracts by encouraging workers to take strike action, they would lose their immunity to those tortious claims and would be potentially exposed to quite significant compensation. However, do I think this will have a major impact? I'd like to say yes for all the commuters out there. Unfortunately, I think it's more window dressing than actually having any real impact. And I say that on two bases. Firstly, unions are proven very adept at adapting to changes to the rules relating to strike action. The government can make strike ballots more difficult to run, but the unions do adapt to them, and they adapt relatively quickly. And so I'd expect them to be able to comply with any of these provisions. And also, the union only has to take reasonable steps. So what's going to happen if you're a train driver and you're told by your union that although most of the workforce are going on strike on the 8th of December, that you have to continue to work to maintain this minimum service level? Well, of course, the union can't force you, and what's going to happen if that driver wakes up on the 8th of December with a bad cold and says that they can't come to work because they're ill? How's that going to be policed? And I think it's that type of issue where the impact of this bill will not have the kind of curtailing of strike action in the rail sector that perhaps the government would like to see. Other future changes, there's lots that the government's talking about. I've got real concerns over bandwidth issues, as I say, as to how much of this will actually go through. We're promised the statutory code of practice on fire and rehire in the near future. Some of you may remember from our discussions earlier in the year around the P&O case and their use, and they aren't actually using fire and rehire as a tactic, but it's certainly, I think, got it high on the agenda. And this use of fire and rehire, so that's the notice of termination to employees with an offer of re-employment on new terms in order to force through changes to terms and conditions. It's not going to be abolished, but this code of practice hopefully will introduce at least some principles that employers will have to follow and perhaps curtail some of the excesses on this. The employment bill, this was this really kind of hodgepodge of employment legislation that covered a wide variety of issues that seems to have been talked about by the government for a number of years. And we're told it's still being considered, but it's something that will be introduced when parliamentary time allows. And I see that as code for not anytime soon. What the government is showing is rather though than introducing its own legislation, is they're now really backing private members' bills to introduce perhaps some of the less controversial aspects of employment law change. So rather than sponsoring legislation themselves, they're actually just backing private members, MPs' bills. So we're seeing neonatal care leave and pay, allocation of tips, carers leave bills, all coming through at some stage because the government's going to back it. We're also going to see protection from redundancy, just highlighting that, because I think that's one that we may see sooner rather than later, although I don't know the exact date. That's the piece of legislation that says at the moment, employees who are on maternity leave and facing redundancy have a priority right over other employees to be offered suitable alternative employment. Now, that priority right at the moment only applies whilst they're on maternity leave. Under this bill, that protection would be extended from the moment they inform their employer that they're pregnant, and would extend as far over as to, I think, 6 months from the date maternity leave ends. So still a protection, but not the ring fencing from redundancy that I know some people have called on to protect those employees who are on maternity leave. So those future changes are there, but as I say, there must be huge bandwidth issues around how much we're actually going to see introduced. And lastly, I just wanted to talk about what I think maybe is the biggest change in 2022, or perhaps the biggest bit of case law. And I know it's something that a number of people have asked me whether we'd be talking about it on this webinar, so I thought I would mention it. And certainly if I was doing the top 10 Christmas countdown of the top of the pop style employment law matters, I think Harpur Trust and Brazel would be straight in at number one because of its impact. And this is because it's now clarified the position in terms of holiday and holiday pay entitlement for part year and irregular hours workers. Now, irregular hours workers include 0 hours workers. So as you can see, has a huge impact. And it's a Supreme Court decision. The implications are still being worked through. Just a brief summary to give us a bit of context. In this case, the claimant works as a music teacher during term time. Her contract extends through the year. She's hourly paid and works variable hours. Now under a contract, she's entitled to 5.6 weeks annual leave, and her contract stipulates that it's to be taken during school holidays. So a third taken at Christmas, a third taken at Easter, and a third taken in the summer. And she's paid accordingly for that holiday. Now, in 2011, the trust, for some reason, decided to change the method by which it calculated holiday and holiday pay, and it started to use the percentage method. It calculated the hours worked at the end of each term. It took 12.07% of that figure, and it paid her the hourly rate for that number of hours using that 12.0% calculation. Now, they're using that 12.07% percentage rate was quite a popular method of calculating holiday for part year and irregular hours workers. I think if you'd see reference to it on the gov.uk website, I think ACAS mentioned it. Lots of contracts were calculating holiday on that basis. But it was controversial. And the claimant in this case said, no, you should use the calendar week method. And this was the method actually the school used prior to 2011. A week's pay for these purposes is calculated under the Employment Rights Act, and you use a 12-week average, ignoring any weeks where earnings were zero, now a 52-week average. And so using the calendar week method, what you would do is you'd say, well, okay, what's been paid to the claimant in the 12 term time weeks prior to the school holiday? You divide that by 12 and pay 1.87 times that for a weekly average, and a holiday pay is calculated on that basis. Now, I appreciate that could be seen as a little technical, but let's bring that to life. What does that mean in practice? If you take the Easter holiday in 2013, if you use the percentage method, Mr. Brazel would be paid £452.50. The calendar week method sees her being paid £687.26. It's not surprising, therefore, that Mr. Brazel wanted the calendar week method. And of course, that's a method that wasn't just being applied to her, it was being applied throughout to part year workers and irregular hours workers. So hugely significant. Not surprising to say that the union fought this because it was a bigger point of principle than this just one employee. And so we saw some varying decisions. Good news for the employer at the Employment Tribunal. They said the percentage method was the right method, but then at all the appellate level, Employment Appeal Tribunal, Court of Appeal, and finally the Supreme Court, it was decided that the calendar week method should be used. So what's the implications of that kind of, I think, certainly, say groundbreaking decision, certainly the ultimate decision of the Supreme Court set the message very clearly. Stop using the percentage methods for part year and irregular hours workers. I know it's difficult, and I've had numbers of conversations with clients who would prefer the answer to be that they can still use the percentage method calculation, but you can't use that going forward. It has to use the calendar week method for part year and irregular hours workers. If you use the calendar week method, how does that work? Well, if, say, an employee decided to take a week's leave, they're a regular hours worker, they take next week off, you look back over the last 52 weeks earnings, ignoring any weeks when their earnings were zero, to work out what their average weekly rate was, and you would pay them on that basis. Now, obviously, that will crystallize the payments at the moment, and you'll be paying on the correct method. There's a risk of backdated holiday pay claims for where you've been underpaying holiday because you've been using the percentage method when you shouldn't. Those claims potentially could be for up to 2 years unpaid holiday. So I think it's worthwhile carrying out some kind of audit if you use the percentage method just to work out what your liability may be. Now, I appreciate that the outcome of Harpur Trust and Brazel is that it can lead to some very strange decisions on holiday pay, and some individuals who only work for very short periods of time during the year are receiving significant holiday pay payments, way above even perhaps payments that the full-time employees are receiving. However, the Supreme Court recognised this was the case, but said that any unfairness in the underlying holiday pay system is for Parliament to resolve rather than the Supreme Court. And it'd be interesting to see if the government, going back to my first session on the retained EU law bill, decides to retain the working time regulations, whether it will make any provision in there as to around how you actually calculate holiday pay in light of all these decisions. So I wanted to highlight the Harpur Trust and Brazel because I think it's probably the one that's got the most publicity and still the one that's causing the most confusion. And if you're struggling still to get to grips with it, let me and the team know and we'll be happy to work through it with you. Hopefully you found that useful in terms of where we're up to in terms of employment law changes. And we're going to finish off the session now. I'm going to hand back to Lindsay and she's going to take us through some other really important case law updates. Over to you, Lindsay.
Thank you. Oh, right, so here we go. We're on the case law update. So we're first going to be looking at long COVID as a disability. Then we're considering a case about the overall fairness of a redundancy procedure. Then we're looking at a case about disability discrimination and redeployment, a case regarding some permanent health insurance, a sex-related harassment case, and an unfair dismissal claim where the employee refuses reinstatement. This is the vanishing dismissal case that Matt was referring to earlier. So let's kick off with Burke and Turning Point Scotland. So this gentleman was a caretaker for Turning Point since 2001. He first contracted COVID in November 2020. Initially, he had mild flu-like symptoms in a similar way as a lot of other people. And after his initial isolation period, he then started to experience symptoms which were really having a substantial adverse impact on his ability to perform his day-to-day activities. So, for example, he couldn't just pop out and buy a newspaper or cook his meals or do the ironing without feeling really exhausted. He was suffering from lack of sleep, joint pain, a loss of appetite, and he was signed off sick by the doctor, who supplied some fit notes which said he was suffering from post-viral fatigue syndrome due to the effects of long COVID. Now, because he was off sick, Turning Point commissioned 2 occupational health reports, both of which concluded that the disability provisions of the Equality Act were unlikely to apply. So in other words, he wasn't likely to be considered to be disabled. His sick pay entitlement ran out in June 2021, and he was then dismissed in August 2021 on the grounds of ill health capability. He brought claims in the Employment Tribunal, and that included a claim for disability discrimination. Now, the Employment Tribunal found that Mr. Burke did have a physical impairment and that his symptoms were consistent with a report by the TUC in June 2021 about long COVID. And the physical impairment was having a substantial adverse impact on his ability to carry out his day-to-day activities. The effect was more than minor or trivial, and it was long-term because the tribunal said that it was expected to last more than 12 months from the act of discrimination, which was the dismissal date. Now, this is a decision by the Employment Tribunal, so it's not binding on other courts, but this ruling might influence other courts and other judges when they're making their decisions, and it might result in more claims from individuals who feel that they've been discriminated against because of the effects of long COVID. Now, what this judgment doesn't say is that long COVID is a disability. It just says that it may amount to a disability. So alongside that, employers really need to consider any reasonable adjustments that would have to be made if you ever have an employee presenting with these sorts of symptoms, because Mr. Burke, when he was going through all of this, sometimes he'd feel a bit better and then he'd have some bad days. So there were good days and bad days, but overall, when he presented his evidence to the tribunal, they accepted that long COVID may amount to a disability and that he had been discriminated against. So if you ever find yourself in this position, keep an open mind and proceed with caution. Although it is worth noting that in this case, the employment tribunal required little or no actual medical evidence to make its decision, to show that long COVID was a disability. So that's a little bit surprising. But anyway, watch this space. I'm sure we're going to see some more cases coming through like this. Okay, so the next case I'm looking at is Osanuga and BPP University legal team. Now, this lady was made redundant from her role within BPP's international team during a restructuring exercise, and she brought unfair dismissal claims in the tribunal against the employer. At the preliminary hearing, the employment judge set out the issues for determination at the full hearing. Now, the issues that were set out did not expressly include a question on the fairness of the overall dismissal. So, whether or not the employer had carried out reasonable consultation, fair selection, and taken reasonable steps to seek alternative employment. In the employment tribunal, the judge concluded that they rejected Ms. Osanugu's unfair dismissal claim. Now, she appealed, arguing that the tribunal should have determined whether or not there'd been a fair selection process, a fair consultation, and a reasonable search for alternative employment, and that they'd failed to do that. And these matters were set out as being central to the fairness of redundancy dismissal. Now, what Ms. Osanugu's case was when she appealed was that she relied on a decision in a case called Langston and Cranfield University. And she argued that these issues, so the overall fairness of a redundancy dismissal, should be considered by the tribunal in a redundancy unfair dismissal claim, whether or not they're specifically set out by the claimant. And the EAT found that, yes, the tribunal had correctly identified that there was a genuine redundancy situation, but they should have considered the issues of whether or not the respondent had carried out a reasonable consultation, adopted a fair basis on which to select for redundancy, and taken reasonable steps to seek alternative employment for the claimant. Claimants are often unrepresented. There may be some of you out there who've been to an employment tribunal and the claimant has represented themselves. And in this case, you may have noticed that judges are very helpful to claimants in that situation because they're not legally trained or qualified and they're doing it by themselves. So the judge will tend to help them. So they don't always articulate their claims properly or clearly enough. So just because the employee hasn't specifically alleged it or raised it doesn't mean that the tribunal won't explore it and won't help them set that out. So it's really important for employers to remember that the issues of selection, consultation, alternative employment are so fundamental to the question of whether or not an overall redundancy dismissal is fair that it is likely that the tribunal will consider it. So even if the claimant hasn't expressly raised it and you find yourself in this position, just be prepared to address it, because it's likely that if that claimant's unrepresented, the judge will help them out with that. Okay, so we've now got the case of Mrs. Bowyers and the DWP. So this is a lady who was disabled. She experienced recurrent migraines. She'd worked for the DWP since 2005 until she was dismissed in 2018. She worked at their Middlesbrough office, and her mental health conditions arose from the fact that she claimed bullying and harassment from a colleague in 2013. Now, she felt that there was a lack of management. She made complaints about this colleague. She asked to be moved. She asked to be moved floors, moved desks, moved offices, and she felt that they hadn't really helped her with this at all. So she went off sick with work-related stress, and she'd raised a grievance. Now, when she was off with stress, she told them that she was willing to work, but not at the Middlesbrough office because of this person that was bullying and harassing her. So they gave her a 6-week trial at an alternative location. Initially, this was based on a phased return to work basis. But eventually the DWP decided this trial hadn't been a success, so they ordered her to get back to work at the Middlesbrough office. Now, she remained off sick for this, and she was eventually dismissed for capability. She brought claims for discrimination arising from her disability. Now, the tribunal upheld her claim. The DWP appealed to the EAT, and they appealed on the basis that the tribunal had focused too much on the process leading up to her dismissal and not on the question of whether the unfavourable treatment, i.e. the dismissal, was a proportionate means of achieving a legitimate aim. So the EAT then sent the case back to the same tribunal who made the same decision, and the DWP appealed again. So on the next appeal, the DWP said, the EAT said that the DWP had potentially legitimate aims in dismissing Mrs. Boyers, and they were protecting public funds, reducing the strain on other staff and resources because of Mrs. Boyers' absence, but that this was not a proportionate means of achieving a legitimate aim, which is a defence to certain forms of discrimination. And they said that DWP hadn't provided any weekly feedback on this trial that Mrs. Boyers did, as they had promised. They'd withdrawn the trial without notice. There'd been IT problems and a lack of training for her. And there hadn't been a proper evaluation of whether or not this trial had been successful. So the DWP couldn't show that the dismissal was a proportionate means of achieving a legitimate aim, especially given the seriousness of the consequences for Mrs. Boyers, because obviously she'd lost her means to earn a living. And they said that had a reasonable work trial been conducted and evaluated, then it's possible that she would have kept her job. So this is really a useful reminder to employers that you must genuinely explore all possibilities before making a decision to dismiss a disabled employee, and actions which look like they're just going through the motions, that will be picked up by a tribunal. Employers really must be able to justify those reasons for dismissal. And if you do an alternative trial somewhere else as part of a reasonable adjustment for a disabled employee without proper feedback or proper assessment, that will be scrutinised if you ended up in a tribunal. So proceed with caution. So we're now going to move on to the case of Amdocs and Langton. So this is a permanent health insurance case, which I think we may have talked about in a webinar before. We blogged about this. Langton worked for Amdocs' predecessor starting in 2003. And when he started work, he was given an offer letter, a summary of benefits sheet and a contract. Now, in the summary of benefits, there was set out a long-term sickness scheme, a permanent health insurance scheme, where you would be paid your salary if you're off sick, and it had an escalator of 5% per year. Amdocs' predecessor had this insurance cover. In 2019, while still working for the predecessor, Langton went off sick and he received this benefit. Then his employment transferred to Amdocs and he was still off sick. He found that the escalator was missing from the payments. So he then took Amdocs to an employment tribunal who decided that he was contractually entitled to the escalator, and therefore they upheld his claim for unlawful deduction from wages. So Amdocs then appealed and said that the correct construction of the documentation was that their obligation was limited. Now, the EAT held that the summary of benefits provided to the claimant contained contractual terms that were clear and certain and intended to be incorporated. Therefore, he did have the contractual right to receive these benefits. Amdocs appealed again. This was a Court of Appeal decision, and they dismissed the appeal. And they were pretty stern about this. They noted that he was given 3 documents when he started work: the offer letter, the summary of benefits, and the contract. He wasn't given the staff handbook, the manual, or a copy of the insurance policies. And the court noted that it is common sometimes for contracts to be in multiple documents, and that if you as an employer wish to limit your liability and your obligations to make such payments, that must be explicitly communicated to the employees. And it wasn't in the documentation that Mr. Langton had been given. It set out the benefits, but there was no limitation of liability for the employer at all. So when we draft contracts for employers, for clients, we always make sure that we put in an explicit provision to say that the employer has the right to vary, replace, amend, or discontinue those that benefit, and that benefit is subject to the scheme rules at all times. I think this case also highlights the importance of due diligence when buying a business, because Amdocs acquired Langton from another business when they bought that business. So it is very important to take those steps to ascertain what you're inheriting, what liabilities you're inheriting, and what benefits and rights do those employees have under their contracts. Okay, so now we're going to move on to the case of Finn and British Bung Manufacturing Company Limited. So this is a case of a bald man who worked as an electrician. Well, he worked as an electrician, but he was bald. Obviously, that's part of the case. But he worked as an electrician, and he was dismissed from his role without notice during an altercation. And his shift supervisor specifically had called him a bald C word. Now, the British Bung Manufacturing Company is a small family-run business, and Mr. Finn had actually worked there for 24 years. Now, the workforce was predominantly male, and this sort of language was fairly normal on the shop floor. But the conduct of Mr. Finn's supervisor in calling him that was found to be unwanted, with the purpose of violating Mr. Finn's dignity and creating a hostile, offensive, and intimidating environment. So therefore, it met the definition of harassment. But the question for the tribunal to decide was calling him bald related to sex? So then would it qualify for sex-related harassment? So they said that although both men and women can lose their hair, they can be bald. Baldness is a characteristic which is more prevalent in men. So there was a connection between bald and Mr. Finn's sex. Therefore, it was sex-related harassment, and he'd been harassed on those grounds, and he was protected under the Equality Act. Although the use of bad language was commonplace in this place of work, this is a useful reminder to employees again. Banter and this kind of language and behaviour should be looked at and should be monitored so that you're not at risk of these kind of claims. We did mention before, we've been locked down and shut down for 2 years and working from home. Some of us are back in the office now. Maybe people need to be reminded how to behave. Policies need to be reinforced, and it is a good idea to train staff and managers to emphasise the risk of these sorts of claims if people are talking to each other in that way, and that's normal. This is a first decision by an employment tribunal, so it's not binding on other courts. And interestingly, all of the panel were follically challenged when they made this decision. I just thought that was a little bit of an interesting quirk of this case as well. So finally, we're going to be talking about Marangakis and Iceland Food. So this is the case of the banish and dismissal. This lady was dismissed for gross misconduct from Iceland Foods, and she appealed by email indicating that she wished to be reinstated. She then attended an appeal hearing, which was postponed so that further investigations could take place. She then sent an email challenging the disciplinary process, and she stated she no longer wished to be reinstated because she felt that the relationship had broken down and the mutual trust and confidence had gone. Iceland reconvened the appeal hearing, in which she reiterated that she didn't want to work there anymore, but they allowed her appeal and they gave her a final written warning with back pay and continuity of service. So a final written warning was substituted for the original decision to dismiss, and that dismissal vanished. However, she did not return to work, and she was then dismissed for a failure to attend. She then went on to bring a claim of unfair dismissal with regards to the original decision to dismiss her, the gross misconduct. Now, the employment tribunal dismissed her claim, and it found that the original dismissal had vanished as a consequence of her appeal succeeding, even though she no longer expressly sought to be reinstated. And they said that an employee can only escape the consequences of a successful appeal if he or she withdraws the appeal, and that the dismissal vanishes upon reinstatement, regardless of motives or the subjective intention of the employee. And that's a well-known concept. It's a concept of long-standing in employment cases. Once that contractual right of appeal is exercised, the agreement between the parties is that appeal should succeed, and that she should have stated clearly that she wished to withdraw her appeal if she wanted to withdraw it. So the Employment Appeal Tribunal rejected her argument, saying that she hadn't objectively and unequivocally withdrawn from the appeal. And they took into account all of those other things, but she should have clearly stated, I withdraw my appeal. And stating that if she wanted to do that, because there might have been some other reasons that she wanted to appeal apart from seeking reinstatement, for example, to make it easier to get another job or something like that. But she continued to participate in the appeal as well. She turned up. So I think in these sort of situations, if you ended up with an employee and they appealed and you reinstated them and then they didn't show up and they took you to an employment tribunal, they'd be highly unlikely to win if they were reinstated. And that brings me to the end of my section. So I will hand back to Matt now.
Hey, Lindsay, thank you for that. I thought that was a really interesting session. Lots of really interesting case law that I think does have an impact for employers. So lots of food for thought. Just before we did have one question in just on the Harpur Trust case. And it's a question that we get asked quite a lot. So the question was that if an employer has a normal policy to give 0-hour workers fixed term contracts, say of only 10 months, with a clear break of 1 month between fixed term contracts, will that protect them from back claims for the percentage method to one fixed term contract period? The answer to that is potentially yes. And we've seen lots of people suggesting about the use of kind of multiple fixed term contracts in this way to mitigate the risks of the Harpur Trust and Brazel case. I still think that's to be worked through. And I don't think it's completely risk-free, but it is certainly a potential in terms of how you addressed the impact of Harpur Trust and Brazel in your organisation. So great question. And thank you so much for everyone remaining with us. I hope you enjoyed that. We certainly enjoyed delivering it. Thank you, Lindsay, as well. Those were two great sessions, and I know certainly that people have already been given some fantastic feedback on that. Hopefully we'll see you all again at some stage in the new year, because I'm sure there'll be lots to talk about in terms of employment law. As I say, we'll be sending out the slides, or the link to the slides and the link to the recording as well at the end of this. And it just leaves me wish you happy Christmas, happy holidays, and we'll see you in 2023. Thank you.
Thanks.